Mr. Langston, you will not lecture this court on the law. The gavel crashes like thunder as Judge Harrington orders the bailiffs forward, not to restrain, but to humiliate. While the courtroom believes they're witnessing the destruction of an overconfident civil rights lawyer, the narrative reveals that for 18 months, David has been building something far more dangerous than a defense. An untouchable judge with 28 years of procedural perfection versus a lawyer who has turned himself into a weapon of documentation to dismantle that judge's legacy. The phone's vibration cuts through the silence of David Langston's one-room office at 11:47 p.m. The fluorescent light above his desk flickers, casting shadows across towers of case files that lean like forgotten monuments. The air smells of burnt coffee and desperation. The scent of a solo civil rights practice operating on fumes and fury. He doesn't recognize the number, but he answers anyway. Late-night calls in his line of work are never good news. Mr. Langston. The voice is young, female, trembling. My name is Shanice Webb. I got your number from the NAACP office. They said you take cases nobody else will. David sits up straighter, pen already in hand. Tell me what happened. The story spills out in fragments. Marcus Webb, 52, pulled over 6 months ago for a defective taillight. What should have been a ticket became a nightmare. They said he resisted. They said he was aggressive. But my father is a church deacon, Mr. Langston. He coaches Little League. And now. Her voice breaks. Now he's paralyzed from the waist down. His spine was shattered. The police report says it was necessary use of force during suspect resistance. David's hand moves across his notepad, but his mind is already racing ahead. Have you spoken to other attorneys? 3 firms. They all said the same thing. The case got assigned to Judge William Harrington in the 117th District Court. They said that's a death sentence for cases like ours. The name hits David like a physical blow. His jaw tightens involuntarily. Judge William Harrington. 28 years on the bench. A living monument to procedural perfection and systemic bias. David thinks of the wall in his apartment. Newspaper clippings, legal filings, dismissal orders, all connected by red string to a single photograph. Judge Harrington, arm around the police union president, both men smiling at a fundraiser. Ms. Webb, David says carefully, I need to ask you something, and I need you to answer honestly. Can your father trust me even when it looks like I'm losing? There's a pause. Then, quietly, yes. Then I'll take the case. After she hangs up, David sits in the flickering light for a long moment. Then he opens his laptop and navigates to an encrypted folder buried 3 levels deep in his hard drive. The folder name reads, Project Oversight. Inside are 18 months of documentation, every Harrington ruling, every pattern, every statistical anomaly that proves what everyone knows but no one can prove. Until now, it's been an archive without purpose. A record without a reckoning. David opens a new subfolder. He labels it, Webb, Marcus, case number 63. The documentation finally has a deadline. The Harris County Civil Courthouse rises from downtown Houston like a concrete tombstone, brutalist architecture designed to intimidate rather than inspire. David arrives at 8:45 a.m. on Monday, 15 minutes before his first appearance in Judge Harrington's court. The building's 3rd floor echoes with the footsteps of lawyers, plaintiffs, and the machinery of justice grinding slowly, often toward injustice. Courtroom 9 surprises him. Despite the building's exterior harshness, this room is designed for theater, rich wood paneling, soaring ceilings with ornate molding, brass fixtures that catch the morning light. But there's a coldness beneath the grandeur, a sense that the script has already been written before any actor takes the stage. Judge William Harrington enters precisely at 9 a.m. 72 years old, silver hair immaculate, he moves with the confidence of a man who has never been challenged and doesn't expect to start today. His voice, when he speaks, is a smooth baritone that never rises, never cracks, which somehow makes every word more menacing. Counsel, state your appearances. David stands. David Langston for the plaintiff, Marcus Webb, Your Honor. The defense table is crowded. 3 city attorneys in expensive suits, their briefcases monogrammed, their smiles practiced. The lead counsel, a woman named Catherine Reeves, nods politely. She's done this dance before. David files his first motion, preservation of body camera footage from the night of Marcus Webb's arrest. He's barely into his second sentence when Harrington's voice cuts through the courtroom like a scalpel. Counsel, this court will not entertain fishing expeditions. Motion denied. Next matter. Your Honor, if I may. You may not. Next matter, Mr. Langston. In the hallway afterward, David packs his briefcase with trembling hands, not from fear, but from the effort of containing his rage. A bailiff approaches, one of the 2 officers he'll come to know as Thomas. The man's smile is practiced, almost fatherly. Mr. Langston, if I can offer some advice. Judge Harrington's been on this bench since before you were born. He doesn't appreciate grandstanding. You might want to think about settlement. Save yourself the headache. It's delivered with warmth, but David hears the message underneath, leave now while you still can. That night, in his apartment, David opens his laptop. The encrypted file grows by another entry. He types methodically, intimidation through proxies, Exhibit 47B. Bailiff Thomas, hallway conversation, 10:23 a.m. Witness, court reporter Janet Mills, visible through courtroom door. Pattern, systemic discouragement of civil rights litigation through informal pressure. The wall behind him is covered in red string, connecting cases, rulings, patterns. 62 dismissed cases. 62 families denied justice. David adds a new photograph to the wall, Marcus Webb in his wheelchair, dignity still intact despite everything stolen from him. Case number 63 has entered the killing field. The certified letter arrives on a Tuesday, 2 weeks into the case. No return address. No postmark that reveals anything useful. Inside, a single sheet of paper with a phone number and a time printed in plain black ink. Call at exactly 9 p.m. Use a clean phone. David borrows a burner phone from a former client, a man he defended against wrongful eviction who now runs a pawn shop on Telephone Road. At 8:55 p.m., David drives to a Shell station parking lot 3 miles from his apartment and makes the call. The voice that answers is female, older, carrying the weight of authority. Mr. Langston. Thank you for your punctuality. Who is this? My name is Patricia Moreno. I served on the 5th Circuit Court of Appeals until my retirement 2 years ago. But this conversation isn't about my past, it's about your present. We know what you're doing. David's blood runs cold. I don't know what you. Please, Mr. Langston. We've been watching Judge Harrington for 5 years. We've also been watching you for 18 months. Your documentation is meticulous. Your patterns are irrefutable. But you lack the legal mechanism to act. That's where we come in. She explains quickly, clinically. The Texas Commission on Judicial Conduct operates a covert oversight unit, a task force so classified that even sitting judges don't know about it. They investigate allegations of systemic judicial misconduct, but they need active litigation to establish legal standing for emergency intervention. We need someone inside, Mr. Langston. Someone willing to continue a case through Harrington's court, documenting every irregularity, every bias, every procedural violation. When the pattern is complete, we provide you with the legal mechanism to trigger an emergency review. But there's a cost. What cost? You must let Marcus Webb's case proceed naturally. You'll lose motions. You'll endure sanctions. Your client will suffer. But that suffering establishes the pattern we need to remove Harrington permanently and review every case he's touched in 5 years. David closes his eyes. The ethical weight of it threatens to crush him. Watch his client suffer. Document injustice without stopping it. Sacrifice the individual for systemic change. How long, he asks. 12 to 18 months. The trial must proceed to verdict or contempt. We need the violation to be so egregious that our intervention is legally justified. David thinks of Marcus Webb in his wheelchair. Of Shanice's tear-streaked face. Of the 62 cases already dismissed. If I say yes, how many people benefit? We estimate 347 cases dismissed under Harrington's procedural bias. 62 with civil rights claims. All of them would be reviewed. David takes a breath. I'm in. The weight settles on him immediately. The knowledge that he's chosen the greater good over the individual. That he's become what he once despised, someone willing to sacrifice the vulnerable for strategy. Judge Moreno's voice softened slightly. This will cost you, Mr. Langston. More than you know. But it's the only way. After he hangs up, David sits in his car for 20 minutes, staring at the Houston skyline. Somewhere in that maze of lights, Marcus Webb is learning to live in a body that no longer works. And David has just agreed to let him suffer longer for a pattern. The phone burns in his hand like evidence of his own compromise. Discovery becomes a war of attrition. David files a request for the police department's use of force training materials, denied as overbroad. He requests the personnel files of the officers involved, denied as protected. He requests the body camera footage from 3 other officers at the scene, denied as irrelevant. Every motion is met with a procedural wall built by the city attorneys and reinforced by Judge Harrington's gavel. Documents go missing. Witnesses become unavailable. The officers involved in Marcus Webb's arrest are granted protective orders limiting their depositions to written interrogatories. Questions they can answer with their lawyers present, rehearsed responses that reveal nothing. David discovers the coordination by accident. He's in the clerk's office filing a motion when his phone slips from his pocket. He reaches down to grab it but leaves it on the floor, recording, while he steps into the hallway. 5 minutes later, he returns, retrieves it, and that night listens to Margaret Sutton, the court clerk who's worked for Harrington for 19 years, tell the city attorney. Judge wants this wrapped up by November. Don't give them anything that extends discovery. The recording is gold. But David can't use it. Not yet. The pattern isn't complete. Meanwhile, Marcus Webb's condition deteriorates. Pressure sores develop into infections. The infections lead to hospitalization. Depression sets in, deep, clinical, life-threatening. Shanice calls David in tears. Why isn't anything happening? Why are they allowed to just delay everything? David wants to tell her the truth. That he's watching her father suffer because the suffering proves the pattern. That he's documenting every injustice to build a case against the system itself. But he can't. The isolation of his mission becomes suffocating. In his apartment, David stares at the wall of evidence. Red string connects 62 dismissed cases. The pattern is undeniable. Civil rights cases dismissed at a 91% rate, always on procedural grounds, always with language that sounds neutral but results in racial disparity. Defense motions granted at 87%. Plaintiff motions granted at 4%. David adds another entry to his spreadsheet. He prints Marcus Webb's latest medical report, the one detailing the infections, and pins it to the wall. Case number 63. The 63rd sacrifice to prove what everyone already knows but no one can prove. David pours himself a whiskey he can't afford and drinks it alone, staring at the faces of people he's failed in service of people he hasn't met yet. The weight of strategy crushes conscience. The hearing on David's motion to compel production of the police department's use of force training materials takes place on a Thursday morning. The courtroom is nearly empty, just David, the city attorneys, and a court reporter whose fingers move mechanically across her stenograph machine. David argues for 20 minutes, citing Texas Rule of Civil Procedure 196.1, explaining how the training materials are directly relevant to whether the officer's actions constituted excessive force. He's passionate but controlled, presenting case law, showing precedent. Judge Harrington listens with visible impatience, his fingers drumming against the bench. When David finishes, the judge doesn't even pause. Mr. Langston, this court finds your motion to be frivolous, filed in bad faith, and designed solely to harass the defendants. The training materials you seek are neither relevant nor proportional to the needs of this case. Furthermore, your repeated attempts to relitigate discovery matters already decided suggests either incompetence or malice. David's chest tightens. Your Honor, I respectfully. I'm not finished. You are hereby sanctioned $15,000, payable within 30 days to the defendants for fees incurred responding to this frivolous motion. Furthermore, you are ordered to complete 6 hours of continuing legal education on proper discovery practice before you file another motion in this court. This hearing is adjourned. The gavel falls. David stands frozen. $15,000. The amount represents 3 months of operating expenses for his practice. More critically, the sanction will be reported to the state bar, potentially triggering a disciplinary investigation that could cost him his license. As he leaves the courtroom, he passes the city attorneys. Catherine Reeves offers a sympathetic smile that doesn't reach her eyes. Derek Vaughn, a young prosecutor with perfectly styled hair, actually winks. David's hands shake, not with fear, but with a rage so pure it threatens to consume him. Outside, he finds a quiet alcove and calls the number Judge Moreno gave him for emergencies. They're trying to destroy me before I can finish, he says, his voice tight. Her response is cold, clinical. Then finish faster. We're 8 months in. You need another 4 to 6 for the pattern to be legally actionable. Can you survive that long? I don't know. Then find a way, Mr. Langston. Because if you quit now, Marcus Webb's suffering means nothing. And Harrington wins for another decade. That night, David spreads 547 pages of documentation across his apartment floor. Every case, every ruling, every pattern, cross-referenced and annotated with legal citations supporting a claim of systematic judicial misconduct under Texas Government Code Section 33.036. He works until 4 a.m., building the weapon that will either destroy Judge Harrington's career or his own. The sanction letter arrives by certified mail 3 days later. David frames it and hangs it on his wall, another exhibit in the case against justice itself. David works late on a Friday, finalizing his appellate strategy for the sanctions ruling. By the time he leaves his office, it's past 11 p.m. Lyons Avenue is deserted, streetlights casting orange pools on cracked pavement. He walks across the street to the parking garage, a 3-story concrete structure that smells of oil and urine. His footsteps echo as he climbs to the second level where his 10-year-old Honda Civic waits, one of only 4 cars left in the entire structure. He's fishing for his keys when he hears footsteps behind him, 2 sets, purposeful, closing distance. David turns. 2 men emerge from the shadows between concrete pillars. One is Thomas, the bailiff from Harrington's courtroom, no longer in uniform but unmistakable. The other is Officer Marcus Drummond, one of the defendants in Marcus Webb's case. They don't touch David, but they position themselves on either side, boxing him against his car. Working late, counselor? Drummond's voice is casual, conversational, which makes it more threatening than any shout. That's dedication. Your client's lucky to have someone so committed. David's heart hammers against his ribs, but he keeps his voice steady. If you have something to say to me, say it during depositions. Thomas shakes his head slowly, almost sadly. See, that's the problem, David. Can I call you David? You keep pushing this case like it's going somewhere. But we both know it's not. Judge knows it. City knows it. Hell, Probably even your client knows it. So why keep making everyone's life difficult? Because it's my job. Drummond steps closer. Your job is gonna get you hurt. Not by us, we're just delivering a message. But there are people who've invested a lot in keeping things the way they are. Union contracts. Political careers. Pension funds. You understand what I'm saying? This isn't just about one case. Is that a threat? It's a fact. Thomas's voice remains friendly, which somehow makes it worse. You're a smart guy. You've got your whole career ahead of you. Don't throw it away on a case you can't win. Settlement offers still on the table. Take it. Move on. Live to fight another day. They leave him there, shaking, furious, and more determined than ever. David waits until their footsteps fade, then drives directly to a 24-hour electronics store on Westheimer. He purchases 3 additional recording devices, 2 hidden cameras, and a cloud backup system. If they want to threaten him, he'll make sure every threat is documented, timestamped, and stored beyond their reach. The next morning, he sends an encrypted message to Judge Moreno, timeline accelerated. Physical intimidation commenced. Need extraction plan ready within 30 days. Her response arrives within minutes, acknowledged. Maintain your position. We're closer than you think. David stares at his reflection in the bathroom mirror, eyes bloodshot, face gaunt, a man being hollowed out by strategy. He thinks of Marcus Webb, of Shanice's tears, of 62 dismissed cases. He thinks of Thomas and Drummond in that parking garage, so confident in their impunity. 30 days, David whispers to his reflection. Then we burn it all down. December 14th arrives like a sentencing. 18 months after Shanice Webb's midnight call, the trial of Webb vs. City of Houston finally begins in courtroom 9. The gallery is packed, police union representatives in the first 3 rows, their arms crossed in unified defiance. Reporters line the back wall, cameras prohibited but notebooks ready. Marcus Webb sits in his wheelchair at the plaintiff's table, his daughter Shanice beside him, both wearing their Sunday best like armor against humiliation. Judge Harrington presides with theatrical authority, his silver hair catching the courtroom lights. From the opening statements, the script is clear. Every objection David makes is overruled before he finishes speaking. Every objection from the defense is sustained with procedural precision. The city's attorneys move through their case like choreographed dancers, never surprised, always prepared. When David tries to introduce expert testimony on the medical evidence of excessive force, Harrington cuts him off, speculative and prejudicial. The jury will disregard. Day 2 is worse. David's witness, a use of force expert from the Police Executive Research Forum, is deemed unqualified despite 30 years of experience. The body camera footage, finally produced after 16 months of litigation, is ruled admissible but only the portions that show Marcus Webb's initial traffic stop, not the 30-second gap during the actual arrest. The breaking point comes on day 3. David is cross-examining Officer Drummond, the man who shattered Marcus Webb's spine. The body camera footage is frozen on the screen, showing the timestamp gap, 17 hours 43 minutes and 22 seconds to 17 hours 43 minutes and 54 seconds. 32 seconds of missing evidence. Officer Drummond, can you explain how a body camera that was functioning before and after the encounter would have a gap during the actual? Sustained. Move on, Mr. Langston. Harrington's voice slices through the question. Your Honor, I haven't finished the question. I said move on. David takes a breath. This is the moment. 18 months of documentation. 547 pages of evidence. 63 cases. All of it converges on the next 10 seconds. Your Honor, I respectfully request that my objection to your sustained ruling be noted for the record, as it appears to contradict the evidentiary standards established in Perry v. Houston Police Department, a Fifth Circuit case that directly addresses the admissibility of The gavel crashes like thunder. Mr. Langston, you will not lecture this court on the law. Your conduct is contemptuous, and this court has tolerated your theatrics long enough. Bailiffs, take Mr. Langston into custody. 72 hours, Harris County Jail, for contempt of court. The courtroom erupts. Reporters surge forward. Shanice screams, "No," as Thomas and another bailiff move toward David. The gallery becomes chaos, activists shouting, police officers standing, Judge Harrington's gavel slamming repeatedly for order. David stands perfectly still as the bailiffs reach him. Thomas takes his left arm. The second bailiff, a younger man named Rodriguez, takes his right. They don't restrain him. They display him. The walk from the defense table to the courtroom door takes 15 seconds, but every camera in the room captures it. A black lawyer in a navy suit, flanked by uniformed officers, his face a mask of determination, walking through a courtroom designed to break him. But as David passes the back row, he makes eye contact with a woman seated among the reporters. Judge Patricia Moreno, no longer retired, present in her official capacity. She gives the slightest nod. The trap has been sprung. Not on David. On Judge William Harrington. David spends exactly 4 hours in the Harris County Jail, processed, photographed, and placed in a holding cell with 3 other men awaiting bond hearings. He doesn't speak. He sits on the concrete bench and watches the clock, knowing that somewhere, machinery far larger than Judge Harrington's courtroom is already in motion. At 6:47 p.m., a guard calls his name. Langston. You've been released. Emergency writ. In the processing area, 2 attorneys wait, a black woman in her 50s and a white man in his 30s, both wearing suits that cost more than David's monthly rent. They introduce themselves as representatives of the Texas Civil Rights Project and the NAACP Legal Defense Fund. They hand him paperwork showing an emergency writ of habeas corpus granted by a 3-judge appellate panel. But attached to the writ is something unprecedented: emergency motion for judicial recusal and investigation. In the matter of Judge William Harrington, 117th District Court. The motion, filed under seal 18 months ago, is now public. It reveals that David Langston has been operating as a confidential legal informant for the Texas Commission on Judicial Conduct's Covert Oversight Unit, documenting systematic judicial misconduct while simultaneously litigating his case. The 3-judge panel orders an immediate halt to all proceedings in Harrington's court and convenes an emergency hearing before the full commission. The news breaks within hours. By midnight, every major news outlet in Texas is running the story. David's documentation, 547 pages of evidence, audio recordings, statistical analysis showing an 89% dismissal rate for civil rights cases compared to 12% for cases where the city is plaintiff, floods the internet. The emergency hearing is scheduled for 10 days later in Austin. It's closed to the public but attended by representatives from every major civil rights organization in the state. David testifies for 7 hours, walking the 9-member commission through each case, each dismissal, each pattern of procedural bias. Judge Harrington sits at the respondents' table with 3 attorneys, his face a mask of controlled rage. For the first time in 28 years, he's the one being questioned. The commission's lead investigator, a woman named Dr. Sandra Chen, asks the question that defines everything. Mr. Langston, you allowed your own client to suffer. To lose motions. To endure a trial you knew was rigged. How do you justify watching Marcus Webb's condition deteriorate while you documented patterns? David's answer is quiet but unflinching. Because Marcus Webb's case isn't just about Marcus Webb. It's about the 346 other cases Judge Harrington has dismissed over 5 years. It's about the system that protected him, that enabled him, that rewarded him with a pension and a legacy while families like the Webbs were told their suffering didn't matter. He pauses, looking directly at the commission members. One case, one client, one injustice, that can be ignored. That can be explained away as an unfortunate outcome. But a pattern? A pattern demands a reckoning. And Judge William Harrington is removed from the bench, effective immediately, for systematic violations of judicial ethics, demonstrable bias in case administration, and conduct prejudicial to the administration of justice. It's only the third time in Texas history a sitting judge has been forcibly removed. The ruling triggers a cascade David never fully anticipated. The Attorney General's office announces a comprehensive review of all 347 cases dismissed in Harrington's court over 5 years. 62 cases involving civil rights claims are granted new trials with reassigned judges. The Houston Police Department's use of force policies come under federal investigation. The police union president resigns. 2 city council members call for reform. But the victory tastes like ashes. Marcus Webb dies of complications from his injuries 8 days after the commission's ruling, 3 weeks before his new trial can begin. The infections that developed during the 18 months of strategic delay overwhelm his weakened immune system. He passes quietly in his sleep, with Shanice holding his hand. At the funeral, held at Greater Mount Zion Baptist Church where Marcus served as deacon, David sits in the back row. He doesn't deserve a place of honor. When the service ends, Shanice finds him. Her face is streaked with tears, but she pulls him into a fierce hug. "Thank you," she whispers. "Thank you for not giving up on him." But David knows the truth. He did give up, strategically, deliberately, in ways that cost Marcus months of suffering. He sacrificed the individual for systemic change, and the knowledge of that compromise is a weight he'll carry forever. David's law practice is flooded with new clients. Families who saw the news coverage, who have their own stories of injustice, who believe he's the hero the headlines claimed. But he finds himself unable to answer the phone. The isolation, the deception, the moral calculation that traded one man's suffering for 346 potential vindications, it's broken something fundamental in him. He takes a 6-month sabbatical. Sees a therapist twice a week. Tries to reconcile the man he became with the lawyer he wanted to be. On a cold January morning, David visits Marcus Webb's grave in Forest Park Cemetery. He places a copy of the commission's ruling on the headstone, official, embossed, permanent. "We won," he says quietly to the granite marker. "But I'm not sure winning was supposed to feel like this." His phone rings. Judge Patricia Moreno. "Mr. Langston, we have a situation developing in Dallas. A federal judge with a similar pattern of bias. We've identified 12 cases over 3 years." David looks back at Marcus Webb's grave, then at the Houston skyline visible through bare winter trees. He thinks of the 62 families granted new trials. Of the systemic change rippling through courtrooms across Texas. Of the price Marcus Webb paid to make it possible. After a long pause, he answers, "Yes. But this time, we do it differently. This time, we protect the clients first. We find another way. There might not be another way. Then we build one." The work continues. The fight continues. But David Langston has learned that justice without mercy is just another form of cruelty, and that sometimes, the real victory isn't in defeating the system, but in refusing to become it. He walks away from the grave, carrying both the weight of what he's done and the determination to do it better. The fight for justice demands sacrifice. But it shouldn't demand souls.